Get ready for the dictation. Start. When the reference was decided in favor of respondent number 3 on 13/4/2012, whereby the order dated 27/1/2000 was set aside and the respondent number 3 was given 50% of his back wages, the present writ petition was filed. The facts of the case are that on 29/12/1999, one Shri Subhash Chandra Jaggi, Vice President and the head of the establishment run by the petitioner, was shot dead inside the factory premises. Thereupon, a fact-finding committee was constituted to identify the culprits who might have been involved in the murder of the Vice President Sri Subhash Chandra Jaggi. Sri Ajay Sharma, the person appointed for conducting the fact-finding inquiry, submitted his report on 21/1/2000, by which he had held the respondent number 3 Pramod Kumar along with one Ajay Kumar guilty of the murder of Subhash Chandra Jaggi. On 27/1/2000, an order terminating the services of respondent number 3 was passed. Aggrieved thereof, the respondent number 3 had raised an industrial dispute which was referred by the state government on 2012/2002 for a decision to the Industrial Tribunal 5 Meerut. In the interim, after the murder of Subhash Chandra Jaggi on 29/12/1999, the police had also, upon a first information report being lodged, submitted a charge sheet on 29/2/2000 and a sessions trial being sessions trial number 647 of 2000 was initiated. The respondent number 3 was released on bail on 16/5/2000 and after a full-fledged trial, the respondent number 3 was finally acquitted in the sessions trial on 28/5/2002. Learned counsel for the petitioner and the learned counsel appearing for respondent number 3 had filed their written submissions, which are made part of the record. The contentions of the learned counsel for the petitioner were as follows. The petitioner could not have retained the respondent number 3 in its establishment, as because of his doings they had no confidence in respondent number 3 at all, and therefore because of the loss of confidence in respondent number 3 the petitioner could not reinstate him. Learned counsel for the petitioner contended that after the murder had taken place on 29/12/1999, a fact-finding inquiry is absolutely unambiguous. Terms had held that the respondent number 3 was definitely involved in the murder, and he submitted that the mere fact that the respondent number 3 had been acquitted by a criminal court would not mean that he could be taken back by the petitioner. Learned counsel submitted that the very fact that the respondent number 3 had absconded after the commission of the murder spoke volumes about the fact that the respondent number 3 was guilty. Still further, learned counsel for the petitioner submitted that the respondent number 3 had been out of service for the past 21 years and now he could not be taken back and adjusted in the establishment of the petitioner. Learned counsel for the petitioner, to support his arguments, relied upon 2012 1 SCC 442 Divisional Controller Karnataka State Road Transport Corporation versus MG Vitthal Rao 2005 to SCC 481 Bharat Heavy Electricals Limited versus M Chandrasekhar Reddy and others, and 2003-99 FLR 24 DCM Sri Ram Industries Limited Meerut versus State of UP and others. The further contention of the learned counsel for the petitioner is that acquittal of the respondent number 3 was not an honorable acquittal but was one which was based on a benefit of doubt. Learned counsel for the petitioner, relying upon various decisions of the apex court, submitted that a departmental inquiry and a criminal trial were held in two different spheres. When a departmental inquiry was held, it was always the intention of the department to see as to whether the establishment would be brought to any harm if the delinquent official is retained in service. He submitted that a domestic inquiry was based on the doctrine of preponderance of probabilities, whereas a criminal trial is based on different considerations altogether. He submitted that in a criminal trial, if there was even a single doubt, the trial resulted in an acquittal and it could always be presumed that the guilty had been discharged of the stigma of being a criminal. However, he submitted that when it was found in the departmental inquiry that the respondent number 3 was involved in the criminal case, then he could not have been retained by the establishment, that is by the petitioner. Stop.